Hello, everyone. This is Tom Fox, and I'd like to welcome you to another episode of Life with GDPR. This is the podcast series where, together with Jonathan Armstrong, partner at Cordery Compliance in London, we take a look at data privacy, data protection, and all issues related to GDPR, the English data protection law, and data protection and data privacy laws in the United States. It's a podcast that every compliance practitioner needs to be listened to and be a part of the discussion going forward for this most important issue in compliance today. I'm Tom Fox, the Compliance Evangelist. Life with GDPR is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back again for another episode of Life with GDPR with Jonathan Armstrong, partner at Cordery in London. Jonathan, welcome.
Thank you very much, Tom.
So, Jonathan, I've been hearing a sort of legal/compliance/market rumors of lawyers flocking to class actions under GDPR in the UK, and even now it's starting to percolate in the United States. What are you seeing around that issue?
Yeah, that is definitely happening. We've got some. I'm not allowed to criticise lawyers professionally, of course. That's the UK rule.
Of course.
If I was, I'd say that some lawyers in this space have ambition beyond their own talent, but we're certainly seeing.
I think you could expand that to lawyers generally.
but we're certainly seeing a bowling in of US lawyers as well in the UK market, particularly trying to expand class actions into the world of GDPR. And it's been good week, bad week for them in some respects. So we've seen that, for example, in the large BA class action. The class action breaks Thursday, Friday, and by Sunday, it seems, a letter before action is sent to BA by a firm connected with a firm of US class action attorneys. So, moral of the story number one is class action lawyers work weekends. So corporate lawyers obviously have to as well. And certainly that's been our experience in connection with data breaches in particular. So there's lots of that type of litigation kicking about. We've just had back in court a class action against Morrisons. Morrisons is a supermarket. And what happened there is quite an interesting case in a number of respects, but to cut it very short, Morrisons had a dispute with an employee. They'd suspected him of running a drugs ring from the office, and he'd been using their post room to send out packages that people were ordering, I believe, over eBay. Now, somebody got suspicious and the police were involved, and they tested the packages and found that they were supplements for bodybuilders rather than prescribed drugs. And the individual was suspended but then reinstated. He felt quite bitter about the way in which he had been handled. There was no suggestion. I believe he'd reimbursed the company for the postage involved. And he was allowed back to his position where he was an IT, in the IT audit crew. Now, then there's a slight unfortunate episode, and I think this is an interesting aspect of the case that doesn't seem to have been looked at. But the auditors arrived to do their annual audit, and they want to audit the salary of employees. Now, in my view, the proper approach, certainly pre-GDPR and definitely post-GDPR, would be for the auditors to say, okay, we've got to test that these employees exist. Give us the pay records of employee 1, of employee 73, 254 or whatever, right. And they randomize the numbers of the records they want, and they analyze those records. So in my view, that's the proper way to do it. If they can do it on premise, even better. But the auditors said that their preferred methodology was for the entire PeopleSoft database to be transferred to them. So
this is getting quite ugly quite quickly.
It is absolutely.
Wow.
And it gets worse. And so they start and do that, and then they realize that the PeopleSoft database is too large to export from their email system. Now, by then, a warning bell the size of the warning bell on the Titanic, you would have thought, would have been clanking away. But regardless, let's proceed. And so they realize that they're going to need a trusted employee to burn all of this stuff onto a CD. And who could they trust more than the guy who's just returned from suspension? So he burns a CD for the auditors, and he takes an insurance copy for himself. And he decides that he's still mad at his employer, and he sends his copy to a newspaper. And a newspaper, effectively with the, this is how bad Morrisons are at data security. They're allowing people to download the entire PeopleSoft database, and he sends that to the newspaper, and the newspaper turn that in, and a police investigation ensues, and the individual is imprisoned, and I think that's about 8 years-ish, so it's a fairly substantial jail sentence for his part in that. Now, what then happens is a firm of lawyers representing some of the employees issue proceedings against Morrisons. They obviously don't want to sue the individual because he's in prison, no visible means of income. So they sue Morrisons. And Morrisons, it's an interesting case in my view, in that it doesn't seem to be an issue in the case whether Morrisons were primarily, whether they had primary liability. So nobody seems to have argued, from what I've seen, that Morrisons didn't take care. But what the case is about really is whether they were vicariously liable for the actions of this rogue employee. And the initial court found that they were, and this week the appeal was lost. So it's probably got to go up to our Supreme Court, but as things stand at the moment, a really significant case, I think, for GDPR, in that I think it goes against what some of us would have thought from our law firm days, that even a bad actor, even somebody who commits a pretty serious criminal offence, is still somebody who the company, corporation, can be responsible for in data protection terms. So I think it possibly increases the bar with things like GDPR training, for example, with things like background checks on employees, with checking that you've got the right guy in the right place. And I suspect the bar is higher than most corporations are prepared for on that liability piece. Now, what happens in terms of damages? So there's, from memory, about 120,000, I think, in the potential class. Only, I think the last time I looked, don't quote me on these numbers, about 12,000 had opted in. And we don't yet know what the level of damages might be. But let's say it's about £1,000 each. It's a fairly significant case probably on that basis. And one would have thought that if they succeed in getting significant damages, then there's the possibility, I guess, of more people opting in and getting closer to the full total of those that were expected. Now, the other thing that I guess is interesting in this context is we've also had another case recently on opt-in, opt-out. And the general rule, of course, in Europe is that you have to opt in to be part of a class action. As I understand it, the general rule in the US is you have to opt out. So the numbers in class actions can be a fairly low order. One of the first, if not the first, consumer class action, I think, in the UK was about Manchester United football shirts. Many people have bought Manchester United football shirts. Very few opted in to the class action. So percentages tend to be low. If Morrisons is around the 10% level, that's probably about as high as any that I can remember. And so we had a case called Vidal Hall, and there's details on our website about the original case. It's over something called the Safari workaround. So it was Google getting data from Apple devices. So we had this initial piece of litigation, Vidal Hall, which was effectively an opt-in action. And then a guy called Richard Lloyd, who was formerly connected with the Consumers Association in the UK, then tried to bring what was essentially an opt-out class action, so a much larger class. And it was quite an unusual action in that he tried to bring the action on behalf of everyone who had ever used a device that ran the Safari browser between a certain set of dates, except for members of the judiciary. And his argument seemed to be that he had to exclude members of the judiciary because they couldn't be a judge in their own trial. And there's been an initial hearing for leave to serve outside of the jurisdiction. And again, we're trying to get more details of that, and we're recording this in Las Vegas, and these things are happening in the UK. But from what it seems is that the judge has rejected that on the basis that not all of the potential claimants have an identity of interest. And what he said is just because something is done without consent doesn't mean necessarily that that causes them harm and distress. And the interesting analogy he's used is surprise parties. He says some people like a surprise party. They might like a surprise birthday party. Just because they've not consented to that party happening doesn't mean to say that they've been caused distress and inconvenience when the party does take place. So it seems as if this decision is going to be followed, that whilst there's a huge expansion of the possibility of bringing claims under GDPR, it's not going to be the free-for-all some would perceive it would be in the US. Yes, under GDPR, there are going to be enhanced rights to claim damages. You're going to have a lower burden of proof to get damages. But we've had the Schrems 2 case, which went to the ECJ over jurisdictional type issues, and it looks as if you're going to have to sue in the nation state court relevant to those data subjects rather than bring one action that covers everybody across the EU. So that could be a limiting factor. And in addition, this opt-in, not opt-out could also be a limiting factor to litigation for privacy cases as well. So I think from my point of view, it's a really interesting, fascinating area. My colleague Andre Bywater has done a lot of work on this, and there's some stuff on our website about it. I think we're going to see a real rise in privacy litigation. But as I say, it's been something of a mixed week, I think, for those who are trying to bring privacy litigation in the EU.
I find it very interesting. Let me just throw out some U.S. legal concepts. With the employee in the Morrisons case, we would call that ultra vires conduct.
Yes, yeah.
Which is generally intentional illegal conduct outside the course and scope of the employment. I guess the sticking point to start with might be, though, that he didn't steal this. He was instructed to procure this data. Now, he did take the second step of making a second copy, but if he's instructed by an employer to make the copy, I guess that to me is a negative factor on the company. But to your additional point of whether you call it background due diligence, whether you call it screening, all of the things that we would see within a standard anti-corruption and a bribery compliance program for an employee, I'm not particularly offended by a company having to take those steps for an employee. Certainly on the training, on the screening, seems like you would really want to look for employees who might be more risky in their jobs, so that if they're in a finance position, you might want to screen for prior fraud activity.
Yeah.
You might want to screen for dodgy bank activity. If they're in IT, you might want to screen to see if they had engaged in such action before. And if you have a obviously disgruntled employee, you might not want to engage in risky behavior of downloading an entire database of PeopleSoft information on your employees or instructing that person to do it. So we also say in the U.S. that bad facts make bad law.
Yeah.
And this really seems to be just a series of bad steps, bad facts, which led to a catastrophic result.
I think that's right, and I think that whilst the court didn't criticise the audit firm involved, you have to ask questions as to whether that is appropriate to do it in that way. I don't think it's a case where a lot of people come out shining with a glorious halo over their head. And perhaps it does illustrate the fact that you do have to be cautious. Under GDPR, if you're going to do something like this, you ought to do what's called a data protection impact assessment, a DPIA. We've talked about that before in our podcasts, and you can go back and download the one on DPIAs and what they mean and what the process is involved. But I would doubt that anybody did a DPIA or PIA, as they used to be called, in this case, and that. I think if you had have done one properly, there would have been warning flags all along the way. Can we trust this employee? Is it right to take data in this way? Can it be done on premise? All of these things, I think, would be warning bells. Are we using DLP software to make sure that the minimum amount of data is being moved around the network? So it's a very unfortunate case, and of course, if it hadn't been, the only person perhaps that comes out with some glory is the newspaper recipient who did the right thing and turned the data back. There are, less scrupulous people could have caused quite a bit of harm with that data.
It's interesting, when you began the telling of the tale, I thought it was going to be the audit firm.
Yeah.
And it speaks to me to two additional needs, one of which you articulated quite well, the DPIA. As a company, you need to sit and think, what is every instance that our data might be leaving? But it also brings up the fact for a vendor, for a consultant, for anyone working with a company, when are we going to receive data? How are we going to receive data? Do we have protections around that? What if that data had been leaked or stolen or even purloined, my favorite Sherlock Holmes word, from the audit firm? What if they had, what was the phrase you used, left it in a cab? Left a disc in a cab. So it's a really, I think, a really prescient example for contractors, vendors, and others that they also need to do DPIAs as well.
Yes. Yeah, I guess I should say from an accuracy point of view, I've sort of paraphrased the case. But it's worth reading the initial trial judgment to see the judge's logic, and I'm awaiting the Court of Appeal judgment to see how much of that they endorse. My gut feel is it probably will go to the Supreme Court, so it might well be that we'll get back to the ultra vires action type scenario that we certainly have had in English law previously. But again, there's another case, bizarrely also involving Morrisons, which concerns a petrol station attendant who went and assaulted a customer, that would also suggest that certainly the appellate courts are, at the very least, narrowing that ultra vires case law and saying that employers are more likely than perhaps they used to be responsible for the actions of employees. One of the logic steps there is saying that it is easier for employers to insure against these episodes, and therefore victims can find recompense versus, suing an individual petrol station attendant who, hits you in the mouth. You're unlikely to get compensation for your injuries that way.
Well, Jonathan, this has been a fascinating exploration of some new data, information, and cases, class actions under GDPR. I look forward to seeing where this might go and look forward to continuing the conversation.
My pleasure.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of Life with GDPR. If you have any questions, you can email me at tfox@tfoxlaw.com. You can email Jonathan at jonathan.armstrong@quarterlycompliance.com. Hope you'll join us again for another episode of Life with GDPR. Life with GDPR is part of the Compliance Podcast Network.